2 big jury win.
Yep, that was good.
And, I know
It's your first time.
I know, well, my second, but...
your first time with me through a jury
First time
trial.
with you, yeah. And it's so fascinating. So one of the things that we have to decide when we're taking on a case and making selections, and like part of the process is, do you want to have judge alone or jury? So how do you decide that?
Depends on the charge, doesn't it? Whether you
facts.
want 12 people, and the facts, right? Do you want 12 people deciding this issue, or do you want one judge because it's a legal-based case, legal issues
What's the
case?
difference, though?
Sympathy, empathy, a sad story, like we were talking earlier.
Common
it's all
sense.
About common sense, yeah.
So,
And it's storytelling. We talked a lot about this earlier. It's all who's gonna listen to a story. You have a legitimate story, like in the trial you did. You had a story.
We'll get into that a little more in detail.
Yeah, we will.
So, it's a question that became more complex over the last 3 years or 4 years because Justin amended the criminal code to get rid of preemptory challenges, which was back in the day we could stand aside or excuse 12 jurors in a regular case, 20 in a homicide, without saying why. And there's all sorts of reasons that a Crown attorney or a defense lawyer would challenge a potential juror because they don't think that they're engaged in the case, that they're not particularly wanting to be there, or there's something that's disturbing us. And generally, I like a jury that's an experienced group of individuals. So, people generally a little older in life and, with a diversity of employment and knowledge. So that's what I look for. And engagement is very important because there's this archaic thing about juror look upon the accused. So they stand up and they look at your client and they look at you. If they're doing this or trying to avoid your client's eyes at all costs, there may be bias there. So so that I thought was always very important. It had only been in existence for a few hundred years, or I don't know how long.
Give or take.
And then, Justin, who's been a criminal trial lawyer in his real life and had studied law exclusively with his very intelligent...
Along with drama.
Yeah, and with his very, very his very astute justice minister who wanted to wipe it out because what they wanted was to have juries that was incredibly representative of the population and that was diverse, and in particular came out of that Saskatchewan case where there was no Indigenous individuals on the jury panel, so she wanted to ensure that there would be Indigenous representation. And the jury we had, I loved, excellent jury. What was so great about them was that you could tell that they were listening, they were leaning forward, they were nodding, they were great. But we had, ultimately we ended up with 10 jurors. It's 12, 2 people got sick. But 9 men 60 plus, 9 men white.
I know.
Right. So, and my client was South Asian.
Yeah.
Right. With a white jury, with one South Asian woman who was on it. And they did a great job.
Yeah, they did.
But I just juxtaposed that with the insanity of saying the whole purpose is to create diversity. Right. I forgot what the quote is. I just got to find it.
You were looking at the Chohan case, though.
Right.
And if I remember correctly, wasn't Chohan an issue where it was an Indigenous person who said they didn't get a...
No, Chohan's not Indigenous. Chohan's a murder case. Dirk was doing the case. Dirk Durstein, who we like and love, great lawyer, lots of great lawyers.
He's got a great name.
Dirk Durstein. Okay, it's great. It's either that or it should be...
You're thinking about Stanley.
Oh, okay. Yeah, right. Because there was a case where they were saying this was an Indigenous person who...
That's the Saskatchewan case.
Who's now suffered because he didn't get the right to eliminate jurors.
No, the victim suffered. So that case, the poor victim is in a truck, pulls up onto the guy's property, gets shot for being on the property. It's a white accused, right. And the lawyer stood aside anybody who was Indigenous. So it was. Yeah,
but some of the challenges after the new legislation eliminating jury preemptory challenges, like there was one where it was an Indigenous person who said he didn't get a chance to equalize the jury because he didn't have preemptory challenge. Anyway,
well, that's
maybe I'm wrong.
No, it could be, but but the Chohan decision went all the way up to the Supreme Court of Canada. Yeah. That's the one that said this legislation is constitutional, and just read that one thing. The Court of Appeal had said this, and it was adopted by the Supreme Court of Canada, that this was...
The part where they say Chohan Ontario Court of Appeal notes in Chohan that eliminating peremptory challenges was intended to address the underrepresentation of Indigenous persons on juries and concerns that peremptory challenges were being used in a discriminatory manner in the selection of juries.
Pause. Okay, so like it just didn't work out that way.
No, it didn't, did it?
Right? And Dirk was trying to explain when he did the appeal to Supreme Court of Canada, was trying to explain, look, math isn't going to work in your favor this way.
Right.
Any number of people you can choose out of 50 or 100 isn't necessarily, without the challenges, going to give you a representative jury. Right? And what just give me, because this kills me so much. So this was a perfect example. It was a great jury. Did their job excellently. We felt immediately that they were engaged. But it was not a diverse jury upon which these geniuses thought it would be. Right. And I remember Dirk was trying to say to me, like, he was trying to explain to the Supreme Court, and they're extremely bright, like, the math is against you guys. Like, the probabilities of getting what you want on just a basis that the first 15 people that show up are like representing everybody in the community is not going to happen.
Right.
In any event, that's what happened. So the decision and the question to try and say to your client, is this a case where it's preceded by indictment, where you get the choice, do you do judge and jury or do you do a judge alone case? That made it much more difficult until we had this experience, and I feel a little better. And I have to say, I'm very thankful to the judge that we had. I know I'm talking a lot, I'm sorry. But the judge that we had did something interesting, which he or she doesn't have to do as a judge. Yeah. And the judge that we had, right on, I commend him. So we did it the same way as the old way. Juror look upon the accused look upon the juror, and then just looked at us and then excused the person. So there's no other jurors in the room, so anybody would get like a bad sense of things. And then he asked us,
"What are your feelings?
What are your feelings? Any comments?"
Wow, that's pretty rare. I've never had that.
It was amazing.
That is,
and there was one juror who came where like I could like just the whole look of the person just scared me because it didn't look like they were engaged at all, and they just didn't want to be there. And in His Honor read my face, and he goes, "Mr. Neuberger, I saw you were either grimacing or making a mark." I go, yeah, I like it. And he excused the person. And good for him, because other judges aren't required to do that. No. So if that's the way we're going to go in the future, that they'll involve us this way, I feel a little bit more secure. But
So my observations, and like I mentioned, I haven't been to that many jury trials, but I'm very sympathetic for their positions because I've seen them sitting there sometimes trying to keep their eyes open, and that
happens to me too.
Yeah,
I'm sitting there.
So like, some people are like super stoked, oh my God, I got a notice for jury selection. Other people are just like, how the hell do I get out of this? Right? Are you happy? You sad? You get selected, and for those people who are really happy and think, oh wow, these are the people we want. We want them to be invested. We want them to take it seriously, understand and explain to them, you're actually like the equivalent of a judge now. You're going to be the trier of fact. Your role here is very important. Do you take it seriously? They are judges,
literally.
But
without the pension.
At the same time,
or the parking spot.
Yeah, that's right. Even more importantly, the
parking spot. Yeah.
At the same time, there's quite a bit of time that can happen in court where the jury is left in the jury waiting room, lounge, wherever they're kept, and they don't know why they're not coming back to court. And the reason is because there's legal discussions going on about what the jury can or cannot hear. And I think it's so important because they're sitting there going, okay, I'm giving you this time. Why am I sitting here in a lounge and I'm not part of the trial? And they have to be told, explain, I'm sorry that it took so long, but we were discussing a legal issue and there's certain things that you can't be here to listen to. They don't know that. I think this is really important.
No, I agree. But do we even say that you shouldn't?
They need to.
No. I know that part, but that these are legal issues that you're not privy to. How about we have some housekeeping to do? Keep it plain language.
Yeah.
Plain language.
But they have to be told.
Yeah, of course.
That we're not just messing around and saying, oh, well, we're not really serious about this trial, so we're supposed to be in trial, but you're just sitting in the lounge for like an extra 2 hours or something like that, right?
Yeah, eating stale pretzels. Yeah.
So, but let's go back. So, I don't think we fleshed out enough because I think it's a really interesting question: jury versus a judge alone. So, So a highly technical legal defense may not be something you want to run in front of a jury because it's something that will be maybe very challenging for a jury to get, with all respect, because it's just so technical. And so you want to go judge alone. But in the vast majority of cases that would go up to the Superior Court because of by indictment, it's a valid option to run a jury. And then just from our discussion, so now we've explained that selection of a jury is pretty straightforward. You don't know their name. You know a number and you know their occupation, and there's not much we can do by way of challenging them unless there's provisions in the code to challenge a juror. It's called challenge for cause. If it's absolutely for bias, which doesn't include sex assault cases, and a couple other things. So there's very limited basis to challenge anybody. That said, it's a valid discussion whether you want your case decided by some judge or by 12 people who live in the community. Mm-hmm. And I think that's a valid consideration, and some people may have a very strong preference to go before, as you call it, a jury of your peers. So I think that's a legitimate thing. I think the other thing to consider, because we do a lot of sexual assault defense work, is a judge in a better position than a jury to decide whether this happened or didn't happen. And there's a lot to be said that, a jury of people who are experienced in life can smell bullshit maybe better than a judge. I don't know. It's a tough decision.
The instructions at the end of a jury trial, I've watched you during your closing submissions to the jury, which is the first time you're asking questions of witnesses. At the end of the trial, it's your first chance to talk directly to the jury, and you gave them some advice on reasonable doubt and so on, which is essentially a part of the judge's instructions. The first one I went to, the judge's instructions took the entire day. So it was from 10 in the morning until at least 4 p.m. with just endless listening to a judge reading, from Watt's manual or whatever. And it was brutal. It was brutal to try and just listen to it and follow it and stay awake. And I don't know how the average person, and I have learned a fair bit about law. Yeah. I can follow it. I don't know how the average person can actually pay attention for an entire day so tell me about this.
I think it's an important point. I want you to comment on that, but I just want to back up for a moment. But they do listen to the evidence.
They do.
So let's separate for 1 second. So you have the trial, and you have people testify, which include your client and the complainant or whoever, whatever it is. Juries do listen. I mean, I've had the benefit of doing well over 100 jury trials, and jurors do listen. I haven't had one case where I felt they didn't listen. In this case, they all listened. They make notes sometimes. So they're engaged in the trial, and they understand, and they hear the evidence, and you can sense that they're getting it sometimes. They may try and remain poker-faced and stoic, but every so often you can see how they react to a piece of evidence, right? And then once all the evidence is done, then as you were talking about, is a judge gives an instruction to a jury. But before that, the Crown and the defense get a chance to...
Actually, let's explain that for a moment. So when you do closing submissions, if the defense doesn't call any evidence, don't call your own client or whatever, the Crown would do closing submissions first.
Okay, so leaving aside the sequence, so what happens in case people are not experienced with it? I think the sequence
is interesting, though.
So the lawyers get to do a closing address to the jury. So that's when we make our submissions to a jury, which I have to tell you is probably one of the best parts of being a lawyer, is you get to craft out this story that you're going to talk to a jury about, and it's a lot of fun. And it's a wonderful opportunity to try and win your case because you can relate to them and you find a way to do it.
But it's not pre-crafted because it's a presentation of what came out at trial.
It is. So you include the evidence, and then what I do is I spend about 30 minutes or 40 minutes talking about the law because you raise an interesting point. When the judge gives the instruction to the jury, that can take 6 hours, and it's going to include an instruction on the law, and some of the jurors might be doing that. So you want to be careful. You want to be careful when you're the lawyer that you do it in a manner that they're going to understand, but you have to get across to them the importance of the law. They have to understand the importance of the presumption of innocence and the importance of what proof beyond a reasonable doubt is. And if if I called my client to testify, I get to go first to the jury. If I don't
You
call
get
any
to,
defense,
though. Is it a benefit?
okay, one sec. So if I don't call evidence, then the Crown goes first and I do. I love going first. I have predominantly gone first in 95% of the jury trials I've done, and I love it. And why? Because you set the tone. I'm the first one to talk to them about the law. I will do it in a very reasonable manner that they can understand, but they will get the sense from me just how serious this is and how important it is that you need proof beyond a reasonable doubt. It's not a joke. Yeah. And you explain that to them. Then the other thing you get them thinking about is your theory. And then when you give your evidence across and why the client should be found not guilty, why there's problems with the Crown's case, you get everybody else you get the Crown trying to argue your case. And I always ask the jury, think about when you're hearing his or her submission, and if you think I haven't raised a point, please think what my answer is. They're thinking about everything I've said in relation to what the Crown's saying. Yeah. I think it's so important to go first.
Yeah, they're comparing right away. Your story there. Sorry, go ahead.
No, you mentioned earlier, so talk a little bit about this storytelling.
Well, it's critical.
And closing submissions.
Right. Like Joe did an excellent job telling the story in the trial you just won. That's what they want to hear. You know, they've been sitting in lounges eating their pretzels and coffee. They hear the boring judge summarize the law, but here's the lawyer telling them the story.
Not all judges are boring. Some actually are fun, but when they're doing jury trials.
There's a few, yeah. But that's what they want. They want ABC. They want the trilogy. They want Star Wars. They want a story. They want a hero. They want a bad guy, a good guy. They want to hear it. And what our job is to piece it together. It's a puzzle for them. Everyone loves a good puzzle, right? So here the defense lawyer is going to stand there and say, okay, here's the box. Here's what I think it should look like. Yeah. Let me put the pieces together for you. Before this other guy or gal even gets up to tell their story, what they feel it should be. I'm going to do the puzzle first. It's done. There you go.
And you said something, the jury wants a bit of drama.
Right.
Judges don't want drama.
No.
But juries, like anybody else.
You've almost made a judge cry before?
That was me just getting upset. But juries want a bit of drama. And it doesn't have to be, it's not Perry Mason and shit like that.
No.
It's much more calmer, and it's not the United States. It's much more.
Yeah, you don't have to put a glove on. And
doesn't fit.
If the glove don't fit, you must acquit.
It's not like that. Jury trials are generally done very elegantly. But, there's something you can do to create a bit of drama, whether it's in a cross-examination, then in your closing address to the jury. You're going to create a bit of emotion and drama, something they can relate to, something they'll hang on to. That's a big difference.
It has to make sense. And that's the whole thing, is that, when we're going through this stuff and trying to figure out how to, what to cross-examine on and stuff, is there's certain things that stand out. And it's that's insane. How does that even make sense? And the thing is, our story makes more sense.
Yeah, so you're talking about, is it plausible? Is there coherence to the story?
Which is more likely? Which is more likely?
Right, and you get away, I think you can do more of an argument to a jury than we can now to judges. So particularly in sexual assault cases, one of the pieces of evidence was, allegedly there was this witness who was very close friends of the complainant who got sexually assaulted, okay? And two people were accused, my client and another one. And they were different acts, but the witness said, I saw Neuberger's client do X, Y, and Z.
She's the friend of the complainant.
The complainant, yeah.
She's literally in the room, and she does nothing either, because she's seeing the same thing.
But at the end of cross-examination, she admitted she didn't see what she said. Okay, in other words, I got her to admit that it's not true.
Her memory was infected by hearing.
But what was really interesting was, because you raised this point, at the end of the day, everybody goes downstairs to leave. The complainant who was sexually assaulted by is going to leave. And then she says to her friend, this witness, saying, well, if you want to go with this guy and spend a night with him and hang out, no problem.
She's like, no, I want to come home with you. She's like, you know what? Stay with this guy who I'm also saying sexually assaulted me. Yeah. But just think about that. In what world?
Right. So she does go off and has a nice evening and spends the night at my client's apartment. But we could say to a jury, What's the plausibility that she just went home with somebody she just saw sexually assault her friend? Does that f***ing make sense
And
to you?
then the girl who's saying that she was sexually assaulted by him goes, yeah, stay with the rapist.
Yeah. Right.
So,
But could we get away
you were
with that to
saying-
a judge?
But you're saying that she was sexually assaulted. It's like, so here's the thing. This is one of the few cases that I've worked on where there's co-accused. And there was a really important point that you made when you were talking to the jury, which is, this is not a package deal, thanks to Marcy.
Marcy's term, yeah.
This is not a package deal. And it was so important for them to understand, you can find this other guy did this thing, but our guy is not a package. This is a totally different allegation. And it's really interesting when you have co-accused, because you can be at cross purposes, where it almost came to the point where saying, our guy's almost a crown witness. Because he went in the room because he literally got a call or was party to a call saying, I'm in distress. Can you please come here?
Yeah, it's really important. I had to spend some time on this with the jury to explain, look, the evidence against my client is separate and distinct from the evidence against the other person. You have to consider this separately. And you can arrive at a conclusion different than the other one. It's completely independent. It's not a package deal, right? But can I just go back to that other point for 1 second?
Yeah. Well, you can do whatever you want.
But just like, we can't say to juries, we can't say to a judge what we can say sometimes to a jury, like, well, Your Honor, what's the chances that the woman who said that she just saw, my client sexually assault will go home with him? And judge will go, well, I can't engage in myth-based reasoning, Mr. Neuberger. Witnesses and people will, I can't say that. I can't say that to a judge, but you can say that to a jury, right? And just one more thing. I love this. What term can you not use with a judge, or a judge can
Common
have?
sense.
Common sense. But what do you tell a f***ing jury? What's the strength? What's the
your common
strength of the
sense.
jury system? Using your collective common sense.
Right.
You can use your collective common sense. So I'm a little more invigorated now, having done this jury trial after Justin's changes to the criminal code. Thank you again, Justin.
Subscribe, Justin.
Because I feel a bit of a sense of unshackledness. I feel very shackled when going before judges in sex assault cases now, because we're asking to twist common sense, to say it doesn't exist anymore. The world as we know it doesn't exist. There's this vacuum that you're in where you have to consider, just like they argued today, the complainant didn't say that there was oral sex as part of the sex, so the accused can't say that. What the are you saying?
There's only one version of events.
There's only one version of events. It's hers.
I know.
Or if it would be a male complainant, it's only his. But juries...
What's our favorite word now?
So much better.
Specious. What's our favorite word now?
It's a specious argument.
Specious arguments.
But, I still don't know, because we do a ton of judge-alone work, trials, and it succeeds, and judges do great jobs, and they write it out. But I think it's an interesting debate. And the point of this was to talk a little bit about, it's a big thing. It's legal advice. You're talking about, okay, judge and jury. And it's not an easy one to answer still, I think.
And here's a little closing point. There's something that we forget quite often to tell clients when we're going in front of a judge alone, which is they'll reserve the decision, and it takes you a month, maybe 2 months to get the decision. So what's the benefit when you have a jury?
It's right away, babe. It's right away.
You're there until they decide.
Right. Captive audience.
I mean, there's a lot of agony for everybody. There's agony for complainants, there's agony for accused, there's agony for the lawyers.
There's agony for the jury that if they can't decide very quickly, they're all sequestered and they're stuck together.
Yeah, and sometimes they won't arrive at a decision.
For days.
You can get a hung jury. You cannot. Sometimes you won't get a verdict. But there is an immediacy to what we call justice. There's an immediacy to it, and I think there's a sense of closure, at least, with that. But I'm more intrigued when trying to decide, is there an emotive aspect of your case? Is there a hook to your case that you can sort of rub into the jury like salt into a wound and go, you can't believe anything they say because of X, Y, and Z?
Well, and in terms of storytelling, as we were talking about,
that's a very good criteria, right?
Yeah.
Exactly what you said. Because a judge, right?
Yeah. And
that's nice, Mr. Neuberger. Next submission.
That's right. Yeah. And I can't even consider that, Mr. Neuberger.
Right.
But when you go into court, nobody knows who you are. And so the storytelling thing is so important because for people to understand what happened, you have to be able to paint that picture of who these people are, so they can they can come to decisions grounded in the evidence about who these people are and whether or not what they did was reasonable given who they are.
Well, and it's making them people again versus accused.
I
right?
know.
Not guilty versus I've created. Here's my client. I want you to learn about him. I want you to meet him.
That's a very important point.
It's huge.
Right. You're humanizing
Yeah.
your client to the jury so they know who he is. They'll see the person's family maybe sitting there. They'll see the mother and father. They'll see the brother and sister or their children. Hopefully not the children.
Hopefully
but,
not the children.
They'll see their family. They'll understand what they do for a living. You can connect with that and then take a hard look at, as a juror, I assume, who this person is. And that's, again, something that's sanitized in a judge-alone trial. Mm-hmm. But it's still, I think, a challenging decision because when a judge renders a verdict, they have to give a written decision. If there's an error, you can appeal it. A jury doesn't give reasons.
Yeah, it's just the jury instructions that you're left with if things go wrong.
And when an accused testifies, I think this is important to consider too. When you're deciding whether to do judge alone or jury, you have to also consider your client, and the client has to consider themselves and the way that they're going to testify. Because I can tell you, if you're in front of a jury and a client who's testifying doesn't really do a good job or gets very combative at the wrong time, certain emotions come out, it can really turn off a jury.
It'll backfire many times too, right?
What happened in our jury trial with the complainant? You asked her a very serious question, and she laughed.
And what did I say?
Are you laughing?
I see you smiling, Miss Such and Such. Are you laughing? Mm-hmm. Is this funny to you?
Not funny at all.
But that and then creating a different scenario pissed off the jury. And that was something that we could just work on, right? Yeah. But you have to be very careful with your clients to make sure that they understand, do they have the personality and the ability to go before a jury? Because a judge will be much more forgiving about those issues and has to go through that thing. And the last thing I'll say is, and you can correct me if I'm wrong, when you're talking about jury telling, your storytelling, storytelling to a jury starts with your cross-examination.
Well, that's the first time you put your story to the jury effectively, right? Through
your cross.
Through your cross.
You have to know how to cross-examine to do it effectively in front of a jury. Do you open to a jury ever in a jury trial? Have you ever opened to a jury in a jury trial?
No.
Explain what opening is.
Making an opening statement, kind of summarizing what you're going to say at the beginning. No.
That's
asking for trouble. Yeah, that's in the movies. No.
Yeah. So but the Crown Attorney. So the Crown Attorney always gets the right to give an opening.
I have seen the Crown do that before.
Crown always does an opening. Always does an opening at the start of trial. Then just before you want to call a defense, that's when the defense can then do an opening, or you can bring a motion to try and open at the same time as the Crown, which is very limited circumstances you can do that. I have never done an opening, and never will.
I'm not going to tell you what you're going to hear. I'm just going to show you.
Yeah.
Right, because not everything works out the way you think it's going to be, right?
Show, don't tell. That's the best part of storytelling. You don't just tell people things, you show them.
You show them, right.
But it was an interesting point because, other lawyers maybe have different opinions and there's no right or wrong way necessarily, although I think you don't open. And I never did. And I always make the joke when the judge says, Mr. Neuberger, are you going to do an opening? I say, the jury only needs to hear me for once, But I just don't think it serves you well. You need to wait till everything is in, all the evidence is in, they got a sense of what your story is, and then you package it up for them and sell it to the jury.
It sets you up for failure otherwise,
I gotta say,
right?
Joseph, you've been trying to sell me on jury trials for a long time, and I've been very skeptical.
Yes.
And this was the first time we've done a jury trial together, and it was delightful to watch.
But didn't you like the jury?
Well, in the end, yeah.
Yeah, I liked them better, but once they acquitted,
it was great, right?
Yeah.
No, they were very engaged. The body language.
I liked the body language.
Body language is very good.
What I really liked was I was looking at them really closely, and I couldn't read them very well, and I liked that because it showed me that they were neutral coming in.
Yeah, I thought they were listening, and then
just like we've seen before, and I understand it to be, when people are on jury, they take their jobs very seriously.
Yeah.
And and I think the best moment for a jury is when they're finally done listening to the charge, the jury, and all the other boring stuff that you're like.
But important.
When they listen to the evidence, they're wide awake. But listen to the lawyers, like, oh my God, it's almost like a drone or whatever. When it's like the law is now in your hands, and now we have to wait for them. Then that's where they kind of go, okay, all of it comes together for them, and And the thing is, it's not just I'm a powerful person, I'm part of a group. And I think, if anybody hasn't seen it, was it 12 Angry Men?
Right.
An amazing film to look at.
No, but I think
We don't know, and they can't talk in Canada. They can't talk about what happens in the deliberations or whatever. But going
and the U.S.
back there,
is so different. It's so different in the United States.
But going back there as a group, and then talking amongst each other about their feelings and their perceptions and their memories of the evidence. And it's one of the things that they're told too. If I summarize the evidence in a way that you don't recall, you go with what you collectively, think happened.
Other than when I make sure I get a transcript of my cross-examination and I'm reading from the transcript and I'm so close to the jury they can read the f***ing page. But I do think there's a team building most of the time where they come together to do it. But anyways, we've talked a lot about it. But I think it's interesting. I think we should revisit it again because we get a lot of these questions about judge versus jury. And I think
it's a big decision.
I think it's an evolving issue
it's a big
now.
Decision.
Where we are with the way people think about certain offenses, and I think this whole thing about jury selection, I think has to play out with a little bit. All right, have a good night.
End of the
I'll
night.
be quiet
End of my
now.
glass.
Thank you. Can you? Hi everybody. Can you like, share, subscribe, and click notification? Have a good night.
Leave
Thank
comments too, because we read.
Yeah, send us comments. We love the comments and questions and stuff you want to hear from us again. Good night, guys.